So, please give us a brief introduction.
Namaskar. I am a graduate. I have done my BBA LLB from Karnataka University. I am a graduate of 2017 batch. Pursuant to that, I started preparing for judicial services examination. And currently, I am practicing in Delhi with a law firm. I'm working as a senior associate, and I'm gaining experience of litigation in Delhi High Court and Supreme Court of India.
Okay, fine. So, what is the reason that since you are already practicing in Delhi, how many years of practice do you have?
I have a 3 years of experience as of now.
Okay, so you give me some good reasons why you are interested in judicial service, since you are in Delhi and you are, having litigation experience. There are a lot of opportunities which are there in front of you, and in most cases, the financial compensation would be much more than that what you would get under judicial service, Odisha judicial service. So give me some good reasons why you are interested in Odisha judicial service. Coming from the current experience background that you have.
Yes. So, sir, the first and foremost reason I would say is from third year, I had decided I have always wanted to go for judicial services examination. And this second biggest reason I would consider for coming to judiciary is since in this 3 years of practice, I have got an opportunity of working on this side of the bar. I have realized how it is very much important to do justice to a matter sitting on that side of the bar because here we get to put a case from one side of the party and so obviously judiciary being a larger bench gives would give me a platform to do a total justice being a biased person to the overall matter, sir. So yes, that is one of the major reason I have learned through my practice, sir. The importance of delivering justice is what litigation has taught me, sir.
So, you work in the advisory capacity, or you are representing your clients in the court also?
Sir, I have got I'll say a 15 to 20% of chance of representing my client. However, most of the cases, in most of the cases, I assist my senior and the briefing counsel in the matter, sir. But yes, I have got a fair chance of appearing before the courts.
Okay, so uh, you know, tell me three important things or three important reforms in the lower judiciary. Okay, that you think should take place. Okay, the reforms in lower judiciary, whatever 3 years experience you're having, your clients or general public who go to the courts, the problems they face. Okay, many problems would be there, but three most important problems which they face, and what reform should be, undertaken so that our judiciary is more accessible to the common people.
Right. So one of the biggest problem I have realized in lower judiciary is the vacancies, sir. So the vacancies are many, and the I don't know why the vacancies are not being filled or whatever the reason might be, because of the lack of the number of judges or maybe the law officers in the courts. The clients, even the advocates, face a lot of problems, sir. So first is that. So secondly is I feel the lower courts have become very much liberal, I would say, in granting adjournments and all, which are not, which is not the case in higher courts, sir. So for example, let's say, sir, in the Delhi High Courts is very much strict in terms of granting adjournments. However, this has become a very casual attitude of the lower courts, as in when a party requests for adjournments, they are ready to give the adjournment, sir, which delays the justice delivering process, sir, which is what I have understood. And sir, one more thing, sir, if I can be specific, so let's say, for example, the matters of 138 matters. The reason 138 was brought into force is that a fast track remedy can be given in case of check bouncing offences, sir. The court, the parliament, the legislature has fixed a timeline, that within this timeline a check bounce case has to be completed. However, that is really not the case when the matter actually approaches the court. So the courts are not really aiming to achieve the reason why the fast track courts have been established, sir, by the legislature, by the government, I'm sorry. So, sir, when it comes to talking about the reforms, I feel the court should go strict in terms of granting what the parties or what the advocates are praying for, and the courts being the justice delivering pillar, they'll have to abide by the timelines, I feel.
Okay, fine. So what are the optionals that you have taken?
So my first option was law of crime, second law of tort, the Transfer of Property Act, and the third was law of contracts, sir.
Okay, fine. So let us start with criminal law then. Acha, you just mentioned about the delays and all. Okay, under the new amended criminal laws, um, has there been dealt with specific period has been given to complete the case? Can you tell us something about that under the new criminal laws?
Uh, so honestly, I'm not very much well versed with the new criminal laws, but one or two changes which I can recall is, so in BNSS, one of the timeline which has been fixed is, the practitioner who will examine the rape victims has to give their reports within 7 days. This is one of the timelines which has been given, sir. And so, in terms of police custody, also, I don't recall the exact date. However, 15 days police custody has now been provided in case of initial 40 or 60 days judicial. So, I'm not really very sure, but there is a change in police custody as well, sir.
Okay. Uh, so, compared to IPC, any new form of punishment has been added to BNS?
A new form of punishment in IPC as compared to this. Uh,
How many punishment or what types of punishments were there under IPC? How many were there?
so, in the previous one,
IPC, yeah.
There were five. The first one was death. The second one was imprisonment for life. The third one was imprisonment, which were divided into rigorous imprisonment and simple imprisonment. So the third one was removed. It was fourth, and the fifth was forfeiture of property, and the sixth one was fine, sir. Fine. This was an old IPC, so I'm not really sure of the new one, sir.
Also, they have added community service, which we have borrowed from the US. So you see in the app, you go to this important. There is one folder,
Yes.
important documents, right? There you
Yes, sir.
will find. In short, you will find the criminal amendment acts. Okay, what things have been added? Just go
Yes.
through that
Yes,
because
I
this
will.
comparative question will be there.
Yes,
They
sir.
might not ask questions like in what section of the new laws, but still then what are the differences, key differences that for all the three laws you prepare that well. That is one
I
important question. Okay, compare Bharatiya Sakshya Adhiniyam with your Indian Evidence Act. Okay, compare BNSS with CRPC. Compare your BNS with IPC.
yes,
Okay,
sir.
at least 5 to 6 important points of difference should be there.
I will, sir. I will. Yes, sir.
Okay, that's fine. Right. Can you tell me what is this concept of plea bargaining and from where we have introduced it and under which amended it was introduced? And since you are attending courts, can you tell actually on ground, has it made any difference, especially related to the pendency of cases?
Uh, So, starting with the fourth one, so honestly, I have not come across any scenario personally with regard to plea bargaining. However, sir, answering the first thing, sir, plea bargaining is dealt in Chapter 21A of the Indian Penal Code, sir. It was added to the Indian Penal Code in the year 2006, sir. So from where it was adopted, I am not really sure, but I guess it's United States. But I'm not really sure of this, sir. However, sir, what the concept of plea bargaining is basically, sir, when the accused approaches the court that he wants a remission, if not, sir, I mean, he admits the accusation against himself. However, he wants that the charges against him can be waived off or can be reduced to certain extent. With the permission of the obviously the complainant and the public prosecutor. So this is what the concept of plea bargaining, sir. So if I'm not wrong, given a situation, does plea bargaining help in can be applied in 138 matters? I'm not really sure, but this is what my understanding is, sir.
Okay, fine. Yes, you are correct. It has been taken from the American jurisprudence. Yes, right. So under IPC, you have come under the doctrine of transfer of malice. Can you tell me something about it? What do you know about the doctrine of transfer of malice?
Yes, sir. So basically, Section 301 of the Indian Penal Code talks about the doctrine of transfer of malice. So it states that when someone can be held liable for culpable homicide of a person whose murder he did not intend, but he committed a murder of some other person. So the law would presume that the he intended the commission of the offense against that particular person. So that's what the doctrine of transferred malice is, sir.
Okay, fine. So you have taken transfer of property also as one of your papers?
Yes, sir.
Okay, so just tell me about the doctrine of election, number one, and doctrine of grant of, doctrine of feeding the estoppel, okay, uh, by grant.
Okay, sir. So, sir, first starting with doctrine of election. Section 35 of the Transfer of Property Act talks about the doctrine of election. So it states that when one person who has no right to transfer of property, when that person professes to transfer the property so to some other person, and on the same hand tries to confer a benefit on the owner of the property. So in that case, the owner of the property will have two options: either to adopt the transaction, or to decline the transaction, sir. So in case he opts to adopt the transaction, he'll have to transfer the property, and the benefit, the transaction, the consideration amount will be given to him. However, if he chooses to decline the transaction, sir, he'll have to waive off the benefit which was being conferred upon him, sir. So this is what the doctrine of transaction is. So, however, one of the important things in doctrine of transaction is the conferment of the benefit and the transfer should be on one and the same person. If it's on the other person, let's say if the benefit is being granted to other person, then the owner need not be bound to elect on that part, sir. So and
Uh,
the other question was feeding the grand by
estoppel,
estoppel. Yes, sir.
and
Yes, sir. So, doctrine of feeding grant by estoppel is dealt in section 43 of the Transfer of Property Act. So, it says that when a person by fraudulently or negligently, I suppose, confers to transfer of property, showing that it is his own property. However, when the property in real is not owned by him. However, if he subsequently acquires the right over that property at any later point of time, he'll be bound to give effect to the transaction which he has fraudulently tried to deal with it previously, sir. So this is what feeding the grant by estoppel is.
okay. So, according to current position of Indian law, can we attribute mens rea to corporate entities, for example, a company or a legal entity? Okay, can mens rea be attributed to a legal entity? It's not non-living. not a person.
Mens rea to foreign entity. Sir, in my understanding, yes, it can be attributed because of the maybe doctrine of attribution. The reason being because an entity is worked through the officials of the corporation. So yes, as per my understanding, it can be attributed, sir, to those who are in significant positions or who are actively involved in the corporations. It can be attributed.
Okay, good. And you have told that is the doctrine of attribution. Okay,
Yes, sir.
because till now, whomever have asked this question, they were unable to answer. I think you are the first one who has answered correctly along with the correct doctrine. That is the doctrine of attribution. And traditionally, actually, in the beginning, it was like Mencia can only be associated with a living person. Okay, but after this Iridium versus Motorola case, I guess in 2010 or 11, um, this concept was brought in by the Supreme Court. Okay, that through the directors or through the people who control the entity, the corporate firm or entity, this malice, if they have some, mens rea can be attributed to the company or the entity. The only thing is that the entity obviously can't be given punishments like imprisonment and all. So only fines and the pecuniary things can be given. Okay, that
But
is clear.
but this doctrine, don't you think has been in force since long? When check bounce case comes, that's how we make the directors liable.
This was one of the important, you can say, landmark cases where it was formalized by the Supreme Court. Okay,
Okay,
Iridium versus Motorola.
Motorola.
I'm not sure about the year. It's either 2010 or 2011. Okay, you can
I
just check.
look into it, sir. Yes,
Um,
sir.
okay, so you have studied in contract law about sub-agency, right? So suppose a sub-agent has been inappropriately appointed. Okay, and due to him, there is a loss to the principal. So, is he liable to the principal or he is liable to the original agent?
Sir, a sub-agent cannot be directly held liable to the principal. He all his liabilities are directly related to the agent only, agent only who has appointed the sub-agent. Unless if the principal, unless the sub-agent has been appointed, if it's in the usual course of the business, then it will go to the principal. Or if the wrong involved was sanctioned or maybe ratified through the principal, then I suppose the liability can go to the principal directly, then through the agent, sir.
Okay, what same question, but here the case is of misrepresentation or fraud. In that case, what would be the liability of the sub-agent to the principal in case of misrepresentation or fraud?
Um, so I'm not really sure of this answer, sir.
Yeah, these are the two exceptions. Okay, you can just go through that
Okay.
that part. Okay. So you were talking about this, check bounce and negotiable instrument act case. Now, suppose um, check is dishonored not because of lack of funds, okay, in the account, but due to some technical issues, like let's say mismatch of signature. Okay, in that case, are there any penal provisions under the NI Act?
So I'm not aware of this in case of
Okay,
mismatch.
just check that. That is, if the check does not go through, not because of unavailability of funds or shortage of funds, but due to other technical reasons. Okay, wrong
Uh,
date. Okay, signature not matching. Okay, check has expired after 3 months. Okay, things like that.
yes, sir.
Okay, now let us come to some opinion-based questions. So, what is your opinion regarding the from various quarters there is this demand for criminalization of marital rape? Okay, which many countries, developed countries have already done. European countries, North America, they have already done. Progressive countries have done that. But in India, it has not been done, and the current government has made it very clear to the Supreme Court that It is not going to do it. Okay. So, what is your opinion? Should marital rape be criminalized? Whatever is your, opinion or answer, you give some good reasons, in favor or against that.
Sir, obviously, I would favor for the criminalization of the marital rape. So, one of the reasons I could give for supporting this is, I mean, because in such cases, the women have not been given, if this is not criminalized, what alternative does women have to seek redressal of this grievance? So one is this: the law does not give any grievance to the women in case of marital rape. And sir, one more thing, sir, maybe the unequal treatment of a married woman than to the unmarried women. So one of I could think of only one reason, as in that they have not been given any sufficient redressal to seek the grievance on it, sir.
Okay. And so you practice in the Delhi High Court, right?
Yes, sir.
And the lower courts in Delhi.
Yes, sir.
Okay, fine. Can you tell me in Delhi High Court how many women judges are there currently?
Delhi High Court. Sir, I don't recall the exact number of women judges, but uh, if by names if I can recall, there are seven and eight. I'm sure, sir, there are more than that, but I don't have the exact number on it, sir. But there is good representation of women judges, but obviously, sir, not in compared to men.
Okay. And what about Supreme Court? How many women judges currently?
So I guess there are two women judges only, two or
Yes,
three, sir, two or three
two,
only.
two. Okay,
Yes.
there are two currently. And what about Odisha High Court?
I'm not really aware of that. I will.
One. Currently one. Yeah. So I'll give that in the PDF. You can just go through that.
Yes, sir.
Um, how many women Chief Justice of India we have had till now?
Women Chief Justice of India. The sir, as of now, we have not had any women Chief Justice of India. We'll have one. I'm not sure Ranganathan ma'am will have the first Chief Justice of India women. Till date, we have not had anyone, any
Uh,
women.
Justice B.V. Nagaratna from
Ah,
Karnataka.
Nagaratna. Yes, yes, sir. B.V.
September
Naganathan.
2027, but I guess
Okay.
she's retiring just after 1 month, October 2027. So she
Yeah.
will be there for
Yes.
around 1.5 months. Okay.
Yes. Yes.
Same thing, same statistics. You should also know, like the first woman judge of Delhi High Court, and if there have been women chief justices of Delhi High Court. Okay, and same thing from Odisha. Odisha, we till now we haven't had any chief justice of Odisha High Court, woman chief justice, but the first judge, woman judge of Odisha High Court was Honorable Justice Amya Kumari Padi. Okay, and till now, including in the current bench, we have had three women judges. Okay, in Odisha High Court, right?
Okay.
So
Yes.
okay, fine. So what can be done to improve the representation of women, both in lower judiciary and in higher judiciary?
Uh, So, first thing is which the government is already doing is the government has now in many states have already given a sufficient reservation in terms of representation of women in judiciary. So, like in the state of Odisha, the women have been given there is a quota, there is a specific reservation for women as well. So, however, maybe in generic, if we talk, maybe more flexible policies can be created for women, like flexible working hours, benefits, maternity benefits, which the government is giving. But yes, these are the benefits which will increase the involvement of the women participation, sir. And I feel so, and more so basically women have been lacking the proper training and support. benefits. So by if we awareness is one of the most important thing policy wise which can be implemented to attract more women in judiciary, sir.
Okay, fine. My next question would be, uh, what is your opinion regarding legalization of same-sex marriages in India after the, decriminalization of this unnatural, the section dealing with unnatural sexual activities. Now, the next demand of the LGBTQIA plus community is legalization of same-sex marriages. Okay, or marriages within the LGBTQIA community. So, what is your opinion? Should we legalize it like many European countries have done?
Uh, yes, sir. The reason being, sir, legal recognition of the same-sex marriage can reduce structural stigma, sir. In terms of everything, sir. I mean, because of this, maybe there is a stigma which negatively impacts the opportunities, access to a particular group, sir. So I feel yes, legalizing it will to a major extent help to remove the stigma and yes sir, in terms of stigma it will be very much helpful.
Okay. Apart from that, their rights are concerned because it's quite a private thing. State need
Yes,
not, get into it. Um Points in favor. If you're going in favor, there are like 3 or 4 points you can give in favor. Okay.
yes sir.
Always, when you're asked an opinion-based question, try to give at least 3 points. Okay. If you have
Got
more,
it.
good, but generally it should not be less than 3 points. Okay.
Yes, sir, and
Right.
also the opinion be very much inclined to what the courts have already decided, or we can just go against it also.
Now, normally, whether you go in favor or against the particular question does not actually fetch the marks. Marks will be based on your legal reasoning, right?
Okay.
Suppose if I ask you, do you agree that Mahatma Gandhi should be called the father of nation? Now there will be most people who will say yes. They will give their reasons, right? So that is the generally with the flow you are going. Everyone knows about it. We have been taught in our textbooks and all. But suppose there is a candidate who can, with his legal reasoning, contest that officially it has never, no one has declared that. Okay, what is the origin of that declaration? Okay, where it has been said that, where the Indian state has said that Mahatma Gandhi is the father of the nation, right? So, and then whatever legal reasoning he can give, right? So he will also get same marks, same type of marks based on the legal reasoning.
Legal
Okay,
reason. Yes.
you are not going to get marks if you say yes or if you say no. Why you have said yes or no, that is more important. So you can go against the tide also, but then your argument should be very convincing, okay, and
No,
rational.
noted, sir.
Okay, fine. So
Follows.
my next question, other paper you have taken, one is okay, transfer of property you have taken, crimes you have taken, and contract you have taken, right?
Yes,
Okay,
yes,
so
sir.
I'll return back to the criminal law. So does a magistrate have the power to arrest himself or herself?
Uh, yes, sir. Magistrate has the power to arrest. However, it has to be done within his jurisdiction. Section 44 of the Act provides that the magistrate can arrest. And yes,
And suppose he wants to arrest beyond his jurisdiction, then what is that possible?
yes, sir. He still can arrest. However, sir, he has to send the warrant of arrest. The warrant of arrest has to be executed through the magistrate exercising the jurisdiction in that particular jurisdiction. So I guess he'll have to send a requisition there, and the arrest has to be done through that magistrate.
No, if he wants to arrest himself or herself beyond. his or her jurisdiction. Is that possible?
Uh, so I'm not sure about it. I don't think so.
Then in that case, he or she has to arrest, okay, just as a private citizen, because a private citizen also has the, okay, power to arrest, right, under CRPC. So in that case, that can be done. Okay,
Yes, sir.
right. Fine. So that will be the end of the interview. Now let us go to the analysis part. So
Yes, sir.
content wise, okay, most of the answers you have given is fine. Okay, you will get the video after one day, so you just analyze that. One thing is that you can there is you like a lot of head movement, neck movement, right? That you can reduce it. How you can give at least two or three, at least two, three, four, whatever number of mirror interviews every day. So you
Okay,
take
sir.
a mirror and you mark three points or X, 3X you can mark, X being the eyes of the interviewers. Okay, three people you consider, and you can write one, two, three above that. And you think that make a set of 30 questions. Already it is given in your app. You can just take it down from there. So first 7 questions, member one is asking. Okay, so 80-90% time you are looking at member one, that first cross. Okay, and rest of the time little bit you are, okay, shifting your eye contact with the other two members so that it does not become monotonous. Okay, so
Right.
that is, and this unnecessary movement of the body, head, hand, that you can just because actually what happens, since you are into litigation, so it becomes a habit. Okay,
Yes.
when you explain something in the court, or if you are in teaching or something, it becomes a habit. There it will look very odd. Okay, if you there is a lot of more than necessary hand movement, we can't sit like a robot. Obviously there will be natural body movements, but then excess body movements that we can adjust, we can. So that is one. Second thing is, that is mostly you have done, but it should be 100%. That is, if you do not know answer, just tell them that you don't know. Okay, but if you know a part of the answer, first finish that part, then say that, okay, the other part I don't know. Okay, don't tell that from the beginning. So suppose they
Right.
have asked you, two or three parts, one question having three parts. You know one part, other two you don't know. So don't start by saying that, sir, I know this, but I don't know this and this. Okay, whatever you know, okay, properly, first finish that. Then you can tell them, sir, the other two parts I am unable to recall, or I do not know, whatever. Okay, so
Yes.
that is another thing. And whenever you are answering, okay, just give some background, one or two sentences only. Okay, uh, if you give a one sentence or two sentence answer, like in 10-15 minutes they'll finish your interview. And this year, since number of students are less, so if you find the mathematical average, it is coming like 20 minutes, 20 plus minutes per candidate. So this
Yes.
mock mirror interviews that you will take, uh, you can record the interview also with your camera phone, or other camcorder or something. That should be at least 30 minutes. So if you are
Okay.
ready with 30-minute interviews, easily you can face a 20-25 minutes interview. Okay, got it. So out of 100, I'll be giving you 65 for today's interview. You try to push it up to 70s or the higher 70s. Okay, in the next interview, right?
Yes, sir. Noted, sir.
Okay. So any other questions if you want to ask, you can ask me, else we'll stop here.
No, sir, I'm clear as of now. I need to work on my legal reasoning question, sir. That I'll work, and I've noted the down the suggestions. I'll work on it, sir.